Does this mean if I start talking, the music goes away? It does. Okay, thanks for everyone who was forced to come back from the coffee and snack break. We're very happy to see you here. In my duties as the MC today, I'm going to introduce the second panel, of which I will also be a part of. This is the panel on the CISG, basically to exclude or not to exclude the CISG, the pros and cons of having the CISG govern your cross-border relationship. What we were aiming to do with this panel is to give you a bit more of a legislative and practical perspective. We've invited experts on various spheres within the CISG and also cross-border disputes on this panel to discuss this with you. I'm only going to do the introduction of the moderator because he is then going to give me another unsolicited introduction. Let me first invite Eric and Katie to please come up to take a seat. We also have two panelists who are dialing in. Oh, there's William. There's Gary. I have absolutely no idea what you guys see. Oh, but we can see you. Okay, good. And let me do a quick introduction of Eric Ng, who is our wonderful moderator for this session. Eric is the Deputy Secretary General of the HKIC, the Hong Kong International Arbitration Center. Prior to joining the HKIAC, he worked for several years as a barrister in law in Hong Kong, where he focused primarily on international commercial and construction arbitrations, as well as general commercial litigation in Hong Kong. And he's worked as counsel as well as tribunal secretary for several major international commercial construction, and financial arbitrations around the world. I was asked to limit my introduction of Eric to this, but I will add on that Eric is a very avid supporter and promoter of international arbitration, Hong Kong as the seat of international arbitration, the HKIAC, as well as the CISG. He has a lot of other accolades that you can see on his bio, which is online. I will turn it over to Eric. Hey, you sit in the middle. Go middle. Eric's going to sit in the middle between the two girls, and I will hand it over to him to introduce the rest of the panel.
Thank you, Sherilyn, and thanks very much for the kind introduction. So, as you can see on the title slide, today's panel 2 will be on the application of the CISG and the pros and cons of applying the CISG to your cross-border relationship. And I'm very pleased to welcome both Sherilyn, who you've been hearing from today in respect, and Katie Kwong, Senior Government Counsel at the DOJ in Hong Kong in person. And then we have also joining us virtually Professor Gary Bell from the National University of Singapore, and William Zhang, who is a board member and general counsel for Ford Motor Company and head of the Beijing branch. To quickly introduce our panel, starting with Gary, as I mentioned, he's associate professor at the Faculty of Law at the National University of Singapore, trained both civil and common law at McGill and Columbia, and is also the Secretary General of the International Academy of Comparative Law. He is an arbitrator in commercial disputes, and he is also teaching CISG and Indonesian law at NUS since 1996. The second virtual participant is William Zhang, again, General Counsel at Ford Motor in China. He is currently serving as a board member and the head of the Beijing branch, and is also the supervisory board position for Ford Model Nanjing, which is the battery electric vehicle venture in China, as well as Jiangling Motor Corporation, which is a publicly listed company. Mr. Zhang has over 20 years of experience in legal practice and general management for multinational companies' operations, and he's closely involved in leading various Ford Motor Company's key transactions, investment projects, and dispute resolutions inside and outside of China. On my left is Sherilyn, who you should not require introduction, but just for some unsolicited accolades. She is partner at Witters at the Litigation and Arbitration Practice, a specialist in cross-border corporate and commercial disputes, international commercial arbitration, and international contracts, notably and very relevant for today, the CISG. Sherilyn acts as counsel, sits as arbitrator, and is also an expert on international arbitration procedures. She's also very active in the international arbitration community, promoting the education and use of international dispute resolution services in various roles, including her role as Deputy Director of the Viz East Moot Competition, which is one of the most important commercial arbitration moot competitions in the world today. And on my right, last but not least, is Katie Kwong, who is Senior Government Counsel at the DOJ of Hong Kong. She is at the International Law Division and provides advice to government bureau and departments on the international law aspects of issues of government policies. This includes providing them with legal support in bilateral and multilateral negotiations, as well as advising them on the implementation of bilateral and multilateral agreements. And as you can see, today's session is going to be about the CISG. Now, the United Nations has recorded many successes over the several decades that it has been in operation, but perhaps none has been more successful than the Convention on International Sale of Goods, which to date has been adopted by 95 countries around the world and has been in place since the 1980s. Hong Kong, as Katie will introduce, has recently adopted the CISG through China, and I think I will now turn it over to Katie to maybe sort of give a little background as to the policy reasons why Hong Kong has adopted the CISG and the logistics of its implementation. So Katie, over to you.
Thank you, Eric, for the kind introduction. And first of all, I would like to give thanks to the Moot Alumni Association and with us for organizing this panel, which provides a timely and valuable opportunity for the sharing of views on this important topic. Timely and relevant because, as Eric has just mentioned, the CISG will apply to the Hong Kong SLR very soon. And regarding the application of the CISG, the Hong Kong SLR government has taken into account the overall benefits that the application may bring to the Hong Kong SLR. And I will just briefly summarize because there are 5 key aspects in this regard. The first one is probably quite important one, is that it has the potential to drive trade growth. As some of you may know, a lot of the major trading members of the World Trade Organization, for example, China, the USA, Japan, as well as nearly half of the countries participating in the Belt and Road Initiative are actually members of the CISG. And in respect of Hong Kong, in 2021, more than half of the top 20 trading partners of Hong Kong have also adopted the CISG. And since the primary objective of the convention is to reduce legal barriers to trade, applying the CISG to Hong Kong has the potential to facilitate trade growth. The second benefit that we think is quite key is that the application could open up new contractual options. In particular, after the application, businesses in Hong Kong can choose to use the CISG as designed, with Hong Kong as the residual law, or alternatively, if they so desire, they can continue to choose local Hong Kong law as the governing law of their contract. And the application could also prevent Hong Kong businesses from being subject to unfamiliar foreign law in their dealing with their overseas counterparts. And this may be particularly important in cases where they find themselves the weaker contractual parties, where they have less bargaining power to maintain the contractual balance, or that they find it hard to argue in terms of trying to get a governing law that's familiar to them. And I think the indirect benefit of the application is also that the application could enhance Hong Kong's competence in handling CISG-related transactions and disputes as local lawyers start handling more and more cases and transactions relating to the convention. And last but not least, the application provides certainty on the question of whether the CISG actually applies to Hong Kong. And that's because in the past, we've noted some cases from foreign court that that there appears to be some doubt in this regard. And so the application of the CIG to the Hong Kong SAR will no doubt remove uncertainty in this respect and therefore reduce associated legal costs in looking at this issue. So these are the main benefits that we see in terms of applying the CIG to the Hong Kong SAR.
Sorry, and Katie, just to come back to this, when can we expect that, and as I understand, the instruments of ratification have been deposited by the People's Republic of China, so when would the CISG come into effect for Hong Kong parties?
So pursuant to the relevant process under Article 153 of the Basic Law and following the requisite notification by the Central People's Central People's Government, the CIG will apply to the Hong Kong SAR from the 1st of December 2022. And I will just mention that the implementing legislation, which is the Sale of Goods United Nations Ordinance, CAP 641, will also come into operation on the same date.
So 1st of December 2022 being the key date for Hong Kong parties to keep in mind. Now, the CISG was created as sort of a hybrid between the common and the civil law in order to create sort of a harmonization between the sales laws of various different countries. As a result, we also see, quite often some practical differences between the application of the CISG and, say, for those who may be used to dealing with the sale of goods ordinance in Hong Kong. Gary, maybe now I would turn it over to you. Maybe just sort of from a high-level overview. Obviously, there are quite a few differences between CISG and Hong Kong sales law, but what are some of the key things that we should keep an eye out for when a contract is governed by the CISG?
Yes, as you mentioned, the CIG is a compromise between civil law and common law to a large extent, and therefore it is not similar in many respects to the Sale of Goods Act or the common law. Amongst the things that you have to be aware of is the interpretation of the contract. Basically, the parole evidence rule does not exist under the CISG. So this is one thing that you have to take into account. It adopts a much more civil law approach. If you look at Article 8, I'm not going to go into the detail, but basically it allows in the interpretation of a contract to look at the negotiation, for example, of the behavior of the parties after the contract has been signed as an evidence of what they meant the contract to be. So therefore, the parole evidence rule is not there. The other difference, I mean, there are so many, but the things that I think we have to be aware of in terms of educating the client, under the CISG, an offer with a time period attached, you have 1 month to consider this offer, is binding. It's not revocable, even if there's no consideration. So this is different from the common law where unless there's consideration, an offer can always be revoked. This is particularly important to make business people aware of this because they can make an offer without consulting the lawyer sometime. And that would mean that if the party is from another country or another jurisdiction, in the case of Hong Kong, that has the CISG, that would mean that the offer would not be revocable. So that's one thing that one has to be aware of. It's also important to understand that even if the same words are used in the CISG, doesn't mean the same thing. For example, Article 25 talks of fundamental breach. Well, we should not look at fundamental breach under the CISG as meaning the same thing as fundamental breach under the common law. So we have to be careful about these false brothers. We really have to look at the CISG as a whole and not try to interpret it using the Sale of Goods Act or cases under the Sale of Goods Act. And another thing that is important to remember is that, that you have to review your standard contract if you want the CISG to apply to it. Either you exclude the CISG in the standard contract, or you have to review the contract to make it consistent with the terminology and the concept that are used in the CISG. And I could go on, but one thing that you have to know is that you can vary the CISG. Article 6 allows you to actually exclude part of CISG. So you can do it piece by piece. You can say I want the CISG to apply to the obligations of the parties, but I don't want it to apply to the formation of a contract, for example. So this is possible to make such choices. Of course, there are many other things. I actually use the CISG to teach comparative law because it's a fantastic tool to show the differences between the civil and the common law and how you can compromise. I mean, for example, another thing is that the contract is formed when the acceptance is received. So the post-box rule of the common law, that in some circumstances the contract is formed when the acceptance is sent, is rejected by the CISG. So there are many, many things that you have to be aware of.
Thanks a lot, Gary. Sherlyn, I think Gary's listed quite a few things, but if you're advising a client, what would be some of the things that you might also on top, or if there's anything that you would add?
So I'm not going to discuss the differences between the CISG and Hong Kong Sales of Goods Act, because that we definitely can leave for Professor Bell. But what I can say when I do advise my clients, because right now a lot of clients wonder about the CISG, and William's going to give us a bit more insight as to whether or not or why that's the CISG is not expressly included in their contracts or excluded. But now with the way that it is in Hong Kong, sometimes you don't really have a choice. Katie's going to correct me if I'm wrong. And if I jump into a different topic, Eric, I apologize, but you're going to be able to fix it anyways. With the extension of the CISG to Hong Kong, there's one particular difference between Hong Kong and mainland China. And basically, the CISG in Hong Kong has not adopted, Gary, if you're nodding, that means I'm right, has not adopted the Article 95 reservation, which basically means, it's a lot of gibberish. Hopefully you're going to go and read all of the articles in the CISG because it is quite relevant. But the reason why this is key when you're advising clients is because in mainland China, they have adopted the Article 95 reservation, which basically does not allow the CISG to apply if one of the parties to the sale of goods contract is not seated in a contract or is not a contracting state. But in Hong Kong, if the analysis of private international law falls to basically Hong Kong law as the default, even if one of the parties to the transaction at issue, so what would be most relevant, for example, for Withers, is if one of the parties is a UK party, the UK is not a signatory to the CISG, but because Hong Kong law applies to that contract, and because you've got international parties, I think it's Article 11B, the CISG will end up applying to that dispute. And that's something that is quite difficult for a lot of clients to understand or to accept, in particularly the in-house counsel who are UK qualified, because they have no idea of how the CISG acts. So this is something that we've been advising most of our clients here in Hong Kong and outside of Hong Kong. It is a benefit, in our opinion, because at the very least, it kind of puts everyone on level field. You know what law you're working with, so long as that you know that that law can apply.
Yeah, thanks, Sherlyn. And again, Gary can correct us. Yeah, Gary, over to you.
I just want to say, and this is a declaration against interest. I'm very happy that Hong Kong has not had Article 95, and unfortunately, Singapore still has a reservation under Article 95. So if people want to have a contract between, want to have the CISG apply, and the contract is with a party in England, they should choose Hong Kong law, not Singapore law, because Singapore law will not allow them to use the CISG. So this is advantage Hong Kong, I'm afraid to say, because I'm actually in Jakarta right now, but I'm usually sitting in Singapore. So I congratulate Hong Kong for making that decision.
Thank you, Gary. I think we're very proud of that. And for those of you who, again, just to clarify, what the Article 95 reservation does is that there's two ways for the CISG to apply. Either both of your buyer and seller are in contracting states to the CISG, or the rules of private international law lead to a contracting state, which is 1B of the CISG. What the Article 95 reservation does is it means that you don't apply 1B, so that the CISG would only apply when the parties are in contracting states. And without the reservation, Hong Kong has taken the broader approach, which is, I think, why Gary and Shirley are saying that it does provide an advantage. While we're talking about advantages, let's talk about the advantages of CISG in respect of a dispute. And I think Katie's already mentioned one, which is that there provides an option, provides greater choice for the parties. But there's also some other advantages in relation to the CISG in respect of a certain sales dispute between parties. Gary, I think when we talked before about this, you said that it's not just in English, right? The CISG also has various other languages, and that could also be construed as an advantage, right?
Yes, I think it is definitely an advantage. I mean, I assume that in Hong Kong, you have adopted the Chinese and the English version of the CISG. But it is a UN treaty, so it is in the 6 official languages of the UN, therefore also in Spanish, in Russian, in Arabic, and I'm missing a language. There's another language, French, of course, my own mother tongue, right? So it is therefore a document that is easily accessible, and the UNCITRAL has been very good at also having documents explaining the CISG in these official languages. So it's easy for many people around the world to have access to the CISG, much easier than to the common law of Hong Kong, which is very difficult to access in terms of case law, and if you're not trained in the common law, it's next to impossible to understand how that works. So it is often, as Katie has said, a very good choice if you, of course, you always prefer your own law, right? You're more familiar. But if you cannot have your own law, you're better off with the CISG, which is a law that you can access and which has some aspects of the common law into it. Then maybe the law, and I'm just naming Indonesia because I'm in Indonesia right now, but that will be very difficult for you, right? So I think it's one of the advantages, the fact that it is a multilingual document. Also, I think that another advantage is that you have to know where to look, but you do have a lot of decisions by courts around the world, both civil and common law courts. And UNCITRAL has done a good job, and others as well, at making these decisions accessible on the internet, or at least a summary of them. And there's also the UNCITRAL Digest that explains the CISG and makes references to. So I often hear common law people saying, oh, there's no case on the CISG. Well, that's because you look at England. England doesn't have the CISG, so stop looking at England and look at the other instruments that gives you access to cases and to doctrine. Lots of books have been written in English and other languages on the CISG. And I think also in the case of Hong Kong, there's a lot of expertise in China on the CISG as well. So that's an advantage you have, having access to that language in that market.
Can I do a quick plug?
Go for it.
Just extending on to Gary's suggestion of there actually is a lot of materials out there on the CISG. There is a wonderful website that has comprised all of the CISG cases, whether in courts or arbitrations that are published, that anyone can access. CISG online-ch. I may be wrong, please Google it, but it is comprised by a very well-known professor of the CISG who's good friends with Gary. And in all fairness, is my husband, so there's the plug right there. But what he and his team have done is they've collected all of the CISG cases from worldwide, and they've got partners in various jurisdictions that will send it to them and translate it into English. So it is a really good way to take a look at how courts and also arbitral tribunals have basically decided disputes under the CISG.
This would also be a good time, I think, to mention the Clout Initiative, which is the case law and UNCITRAL texts, which is, again, also a very large database full of case law from around various different jurisdictions, all translated into various languages and available for people to research and find information on. Now, we've talked a little bit about advantages, and I think we've left William out of the conversation just now. I think now we could talk about the other side of the coin, which is that despite the success of the CISG, we still have many companies which exclude the CISG. And as I understand, William, not to put you on the spot, Ford Motor Company is one of those companies which does exclude the CISG in terms of the contracts. And so it would be only fair for us to mention and discuss the disadvantages of applying the CISG. So William, if I could maybe turn it over to you to sort of explain the concerns that a company like Ford would have in respect of applying the CISG to its contracts.
Okay, thank you, Eric. So let me just give a very quick introduction on the the commercial setup we're in for applying the CISG. I think for a multinational company like Ford, we sourcing parts from all over the world from different suppliers in different markets and jurisdictions. And if you can imagine, one vehicle will consist, thousands of parts to be assembled in the manufacturing plant. So the most critical issue for a multinational automaker is to manage its supply base through a relatively standard practice. So in order to increase our purchasing efficiency and reduce the complexities, we actually develop our own global standard terms and conditions for purchasing of components and service. And in that template, it actually is express exclusion of a CISG. First, the global terms and conditions is a 40 and 50-page long document with a lot of specific issues and terms addressing the automaker's concern in the supply base. And also, we are issuing supplementary web guides and terms to add address additional issue arising from the practice. So on that side, the reason for our exclusion of the CISG is because when we develop the global terms and conditions, we actually seek input from lawyers, in-house lawyers, and outside counsels in our different operational teams across the different markets. And they are experts of their local law, but they are not necessarily the experts of the CISG. Especially they're not trained by Gary and Katie, so they don't have the expertise to provide the input when developing the general template. And second concern is actually when we rely on the in-house team locally to manage the dispute. And as a buyer, we often choose the buyer's country's domestic law as the governing law for the purchasing orders. And as you guys mentioned, sometimes the CISG might become applicable as a default governing law if the domestic law is incorporating the CISG. So in that case, when you run into a dispute resolution and the local lawyers are not familiar with the CISG, that will create complexities in our dispute resolution and in our purchasing team's handling of the contract and dealing with the suppliers. So out of that practical reason, we exclude CISG expressly so that, we have a predictable and relatively stable choice of law clause. And also the other reason we exclude CISG is when we do our general terms and conditions, we use it for both purchase of goods and service, because nowadays, if you look at the industry, you're not merely purchasing components or the goods. In many times, the service are combined with the goods. For example, software development or engineering service. So we have to have one template to governing all the sourcings. Otherwise, the operation team will be confused, and there's a lot of inefficiency. But the CISG only applies to sales of goods. So that actually makes our, if we choose the CISG, then we have to develop a separate set of the service terms and conditions. That is not very efficient for the multinational companies. And the last reason is that many suppliers are actually multinational companies. They have a similar concern like the OEMs. And that's why, there's a common interest just to exclude the CISG, but rather choose domestic law. Over to you, Eric.
Thanks a lot, William. Very, very insightful as to the approach from a multinational. Sherlyn, what you've been dealing with a lot of clients, and from what we understand, a lot of them also exclude the CISG. Are there any reasons why they do that, in addition to what maybe William has said?
Definitely fully support what William has said, but we also get the clients that just don't understand the CISG, and they'll tell you straight out the reason why they excluded in all of their contracts and they expressly excluded is because They just don't know about the CISG. In all fairness, these are general counsels whom are of the older generation. So about 10, 20 years ago when they were studying law, 20, 30 years ago, they didn't really teach about the CISG in law school. What we have now started to see, and I have to give props to the Vis Moot competition, the younger generation of lawyers, in-house counsel, legal practitioners, they're starting to understand the CISG, and they're starting to see the benefits of expressly including it, or perhaps purposely just not mentioning it. We had a situation earlier this year where a client came to me, and it was a again, a multinational company against another multinational company involving the sale of conveyor belts. The contract was entered into between parent companies, one based in Australia, the other company based in Poland, but it was for the supply of conveyor belts that were to be delivered to a project in Panama. They had a series of other subcontracts and various other contracts that were involved in this overall transaction, and there was no express exclusion of the CISG, and every single contract had a different governing law. But the upside was, and I think thankfully it never got to the actual arbitration, but the upside was every single governing law basically would have defaulted to the CISG. So at least the lawyers could actually understand what law would have been applicable to the dispute at hand.
Thank you, Sherlyn. And I think one of the things, I think, Gary, you've been in Singapore where you've had several years of experience with the CISG. And one of the complaints that we do hear sometimes about the CISG is that there doesn't seem to be many court cases in relation to the CISG. So could you maybe expand on that a little bit?
Yes, CISG came into force in Singapore in 95, I think, or early 96. So it's been quite a while, and we do not have any case actually from the courts in Singapore that applies to CISG. In large part, and I have to agree with Charlene, because people at first just excluded it systematically. Frankly, if I may say, for a lawyer to exclude the CISG without knowing what's in it, which could be beneficial to its client, is actually a professional fault. It's a professional a lack of duty, respect for your own duty. You have a duty to your client to give advice, and the CISG will be part of Hong Kong law. You should become familiar, or you're not a very good lawyer for your client. So frankly, now that does not mean that you have to recommend to your client that a CISG must apply in every case. There are good reasons why the CISG should sometimes be rejected. For example, in certain fields, for example, some fields of law are governed by English law. This is a standard contract that everyone in this industry uses. You can't really change that because it's not going to work, because there's a chain of contracts of sale. The goods are sold while they're still at sea. And if they have to have all the same law, and it's traditionally been the English law. So I'm not saying that you have to constantly apply the CISG, but you have to consider it. Because that's your duty to give good advice to your client. That being said, there's also a different problem, which I think William has mentioned, but I want to press a little bit, is that I think that with the integration of supply chains, and for example, if you take Apple, they are in China checking the quality of the goods and making sure they're delivered on time. And it goes on from Taiwan to China and then back there. And they follow all of this. Lots of sales happen, but it's all in-house, if you wish. If there's a problem of quality or a problem with delivery, which are the two main things that the CISG actually governs, they will deal with it within their long-term contracts they have with suppliers without going to court, without going to arbitration. So that's part of why there are fewer cases. And that's not me who says that. One of my PhD students wrote a fantastic thesis on that, showing industry by industry how number of cases are reduced once the industry has integrated supply chain. So it's quite an important discovery, in my view, by my student. I won't take the credit for that. So there are many reasons why that is, but it is a bit frustrating. I know the English judges are constantly complaining that there are no cases of law of sale anymore in the courts in England because they all go to arbitration. Well, I sit as an arbitrator and I don't see these cases. There are some, but not that many necessarily that go to arbitration. Actually, there's only one case in Singapore where the courts considered the CISG and whether it applies, and it was a case where an application for setting aside an arbitration in which I was the arbitrator. So I know very well how few cases there are, because the only case there is one in which I was involved myself. But the main point to remember, in my view, is that this is a choice. Hong Kong made the right decision, in my view, in giving the parties a choice of law. Basically, you should consider it. It's a good law. It's not good for every circumstance, not for every client, but it's a good thing to give the parties a choice.
Thanks, Gary. And I think that choice also stems back to the first point that we talked about, which was differences, because a choice usually indicates that there's a different option. And in certain sectors, industries, for example, I know the last panel has talked about some questions arising from the commodities trade. How the CISG would apply in relation to a commodities dispute would possibly be quite different, especially in regards to, say, fundamental breach as opposed to, say, common law. Right? Maritime sectors are pretty much dominated by English law. And so having them change to the CISG may create some issues there. Katie, I realize we didn't ask in relation to differences, what the DOJ's perspective is in terms of the differences between the practical differences between the Hong Kong common law and the CISG. Is there anything that you would like to add on that?
So perhaps I will start with that. The CISG is, as you know, is a set of uniform rules for international trade. So it's inherently a compromise between the different legal traditions of the world. So it's inevitable that there would be rules and concepts embedded in the CISG that are different from the ones of the Hong Kong SAR. But we think that in looking at the practical differences between the CISG and local Hong Kong sales law, it will be important to bear in mind that the fundamental concept of the CISG is the primacy of the contract. And this is enshrined in Article 6 of the Convention, which allows parties to derogate or vary essentially any of the provision of the Convention, or if they if they consider that it's appropriate or desirable to do so, they can opt out of it entirely. And so taking into account this important principle of the CISG, in practice, there may not be as much difference, practically speaking, between the CISG and the Hong Kong local law. And so, as perhaps one might initially expect. So, I agree with Gary completely that for legal practitioners, before advising their clients on whether to opt out, they should really be familiar with the CISG, knowing what are the benefits of it, or if in cases where it may not be appropriate to their clients' transactions, maybe in those cases, then they can consider whether to vary it or whether to exclude it completely. But bearing in mind that there may be professional negligence concerns if the clients are advised to opt out to their disadvantages.
And again, I think that goes directly to the point that the CISG may provide different options for buyers as opposed to sellers, as opposed to the common law, and there needs to be some analysis there. I see, Gary, you want to add something?
Yeah, I fully agree with what Katie just said. And I want to say that when you look, I'm talking here to a common law audience mainly, right? People from Hong Kong. And a common law that has been very close to England. Therefore, if you trade in England, you heard a lot of people talk against the CISG, including some of my colleagues, academics. I urge you to look at the CISG without the prejudices, to look at it afresh as something that is different and might be good. Don't look at it as, oh, it's not the Sale of Goods Act. No, it's not. It's not a Sale of Goods Act, but it might be a thing. I think one of the difficulty with the CISG is that people look at it with their own background, whether it's civil law or common law. They don't look at it as a fresh compromise, a fresh new thing. And I really think you should. It's not that difficult to get a good grounding in the CISG. It's not a long convention to read. There are some very good books that you can read. Over a weekend, you can be pretty knowledgeable about the CISG if you spend the whole weekend reading about it. So it's not a formidable task to become familiar with the CISG. So I don't want lawyers to say, oh, we'll exclude it. We don't have time to look at the CISG. It's not that difficult.
Interrupt also?
Absolutely.
Sorry. So one more thing to kind of tag on to that, and I think maybe William, you can tell me if maybe your commercial teams have had different experiences. But I had another situation this summer where the client itself actually wasn't the general counsel of the company. The client were the commercial teams, right? Your CEO or your head of sales, your managing director of companies, and they came to us basically in negotiations. This makes it an interesting twist because it was between a Malaysian party and technically a Taiwanese party. And we know that Taiwan is, whether or not the CISG extends in Taiwan, that's something that you can look into and research. But what the commercial team was trying to get out of us as their external legal counsel is what law out there would be most beneficial and promote and support the fact that the parties will try to carry out the contract to the end and not give either side an easy way out. And so what we said to the commercial team, and Gary, you're going to help me here, under the CISG, one of the principles is it's quite difficult to terminate a contract completely. As Gary mentioned earlier, Article 25 defines a fundamental breach, and one of the ways of voiding a contract is for a fundamental breach to occur. But a fundamental breach under the CISG is not the same thing as a fundamental breach under Hong Kong law, New York law, etc. There are these three prongs that you have to meet, and it's almost impossible to meet, depending on what side you're hearing the argument on, but the breach itself has to be material, and it has to be something that was not reasonably foreseeable. Giving the commercial teams these extra tidbits of advice, they were actually convinced to put the CISG into the contract because it reassured both of the commercial sides that both parties would try with their best to carry out the contract to its very end. And it actually worked really well because it was right in the middle of a COVID pandemic, and it was for the sale, and actually it was a commodity. It was for the sale of rubber.
And I think that goes also to maybe marked as an advantage is that, the CISG sometimes provides a good middle ground. I mean, it's meant to be a middle ground. So what it might potentially do is actually lower negotiation costs. You're spending less time at the table trying to hash out what the governing law should be when the CISG could provide a nice compromise, or at least certain provisions of it, because I think as everyone from the panel has sort of pointed out, this is a choice. You can vary, you can add whatever provisions you can want, you can deprecate or take out whatever provisions you want. Gary, back to you.
Just to add one advantage of CISG, and that's following from what Charlene has just mentioned. The CISG is a law of sale for international sale. The Sale of Goods Act is not necessarily, it could be for domestic sales. Many domestic law of sale are conceived in the domestic context. Now, what Charlene just explained, it makes sense in an international context. Why does the CISG make it difficult to avoid the contract, to avoid the obligation? Because it's an international contract. The goods will have travel for a month. And if you actually cancel the contract or say, we avoid the contract, we cancel the contract, you have to ship back the goods. So this makes much less sense in an international sale than it might in a domestic sale where, you just have to move the goods from Hong Kong Island to Kowloon, right? So it is a very different context. And in some circumstances, it's a better law because it's conceived as an international law.
And those protections are built into the CISG as well, because there are example obligations, for example, for buyers to inspect the goods, and the waiver of their right to make any claims if they fail to do proper inspections, which are, in many ways protects the seller from having to then pay for the cost of shipping the goods back to them. Let's turn this back to William now. I don't think that the point of this panel was not to convince Ford Motor Company to adopt the CISG in its standard contracts, but given the conversation, do you see any situations or do you see any possibilities where the CISG could possibly make sense or where it could possibly be used? And also feel free to say no if that is the case.
Yeah, I think, Eric, the choice we made for exclusion is actually more of a practical consideration, right? It's because the in-house team and the purchasing team are generally not familiar with the CSG as you guys described, right? I think with the more countries are adopting it and more education being provided, situation could change, right? I think that's the first consideration. The second thing, I do appreciate you guys' point, right? If you look at the multinational companies, when we do the purchasing deals, we have a lot of bargaining power, so we can force the seller actually to agree to the buyer's domestic law as a governing law. And in those type of transactions, the concern from the company is primarily to make sure we can repetitively apply a template so that you don't need to rely on the lawyers to advise on the contract time to time, because there's so many buying transactions going on. But in a closer or relatively equal negotiations, I think like you guys said, the CSG is an acceptable compromise, a choice, because if the parties both have a bargaining power and then going on negotiation back and forth for a long time, neither side can convince the other side to take their choice of their preferred governing law. Then probably international treaty is a more balanced and acceptable approach. So I think that's basically my reflection out of this discussion.
Thanks, William. And I think that sort of takes us to the last point, which we wanted to discuss, which is now Hong Kong has adopted the CISG. It will come into force on the 1st of December 2022. And I think the takeaway from this discussion we've seen is that, firstly, the CISG is a choice. But secondly, that we can chalk up a lot of the exclusions, or we can account a lot of the exclusions to perhaps unfamiliarity with the CISG. With the adoption in Hong Kong of the CISG on the 1st of December and its critical place in the global trade market as a trade hub, do we see this analysis changing in the future? Do we see law schools, for example, now incorporating CISG training in their programs? Are we going to see law firms now going into the situation of providing advice in relation to the benefits or disadvantages of applying the CISG? Let's maybe start with Sherilyn, because also your unique position with the Viz East moot, which is one of the great educational venues for the CISG and arbitration.
Another full disclosure, Eric is on the board of directors for the Viz East Moot Foundation. But with that being said, the Viz Moot, which originated in Vienna now 30 years ago, they had already envisioned that the CISG would be something that would be truly big in the future. And I think they've now educated 30 years in Vienna and 20 years here in Hong Kong of students every year that now have good knowledge of the CISG. Now, I've seen law firms in particular in Hong Kong, in particular UK-based law firms who have offices here in Hong Kong, have been making lots of demands to CISG experts to give their internal teams, in-house teams, lessons on the CISG, because they need to put their legal practitioners up to speed, bring them up to speed so that they know how to properly advise the clients. Now, you've heard a couple times today that it really can be a professional an issue with your professional obligation if you end up advising against the CISG and it harms your client. And I can tell you this, there have been a couple cases in particular in Germany, Austria, and Switzerland where legal professionals have been fined, have been taken to court by companies and fined and found guilty of breaching their obligations because they actually advised the client to expressly exclude the CISG. So sorry, the question was about the future. In the future, I do see the CISG becoming more and more relevant in international practice. I do see schools, hopefully, all the universities here in Hong Kong will hopefully offer CISG courses. We've got wonderful speakers, one right on the screen. Other speakers on the panel would be happy to do it. William, I'm going to go to China and visit you. If you take me out for huoguo, I will teach all of your in-house team anything about the CISG that they want to know. But I do believe it's a law that's here to stay, and it will just have more and more use as international trade increases.
And maybe, Katie, from the DOJ's perspective, how do you see the adoption of the CISG affecting Hong Kong's position? I think you've mentioned briefly about trade growth and things like that, but do you think it does provide an advantage?
I think I'm very happy to know from Charlene just now that it actually, the legal industry and also maybe university students, they are actually quite interested in learning more about the CISG. And I think that actually meets one of the objectives that we hope that will bring benefit in terms of the application is to enhance the legal profession in here regarding the competence in advising whether it's CIG-related transactions or resolving the disputes. And I think that is a good thing to know. It will be helpful to their career as well.
Gary, any final comments from you?
Well, yes, there is a future for the CIG. I think it's encouraging that it's adopted more and more by more and more countries and by more and more practitioners. It doesn't mean it will necessarily lead to dispute, but it's also a good way of solving this potential dispute without having to go to court once you have a law that everybody understands and understand their own obligations. Teaching the CIG for 27 years, sometimes I have the impression of preaching in the desert, because in Singapore I haven't seen many cases. But nonetheless, I think it's an important task to educate the future lawyers as well as a present lawyer. And again, I'm repeating myself, but it is not that difficult. I don't want to say that the CIG is simplistic, because I would confirm what many common law lawyers think about the civil law codified law. It is not simple. It can deal with very complex cases. It has an ability to deal with complex cases, but it is not in and of itself complex. That's the beauty of a codified law, is that you can read it, and then once you have a problem, you know where the problem fits, which article it fits on, and you can do specific research on that quite easily. So that's the future, I think, knowing the CIG, then deciding whether that's good for your client.
And finally, William, any final comments from you as to where you think this future is going to go?
Yeah, first, I'll say to Charlene, welcome to Beijing, right? Of course, we'll host you for dinner, right? Hopefully, over dinner we can get familiar with the CISG. And also, we can get certified by you and possibly Gary, so that, we can advise our corporate clients in a more eloquent way. Certainly, with more and more countries and legal communities adopting the CISG, I think there's a need for in-house lawyers to get trained and familiar with that. At least in a negotiation, right, we can be better prepared and advise our internal clients. So counting on you guys to do this promotion and training for all the legal communities.
Thank you, William. And I think that just leaves it to me to give a couple final takeaways before we open the floor to questions, which is, I think you've heard over the course of this panel that the CISG, essentially the key takeaway is that it provides an option, provides a choice. There are certain things in the CISG which would be more advantageous for various parties as opposed to the common law, and likewise there are going to be situations where the CISG may not be as advantageous in respect of applying it to certain contracts. And that's really going to come down to the practical reality of your relationship with your buyers, with your sellers, the nature of your supply chain, the nature of your industry. But what it does provide is a choice. It provides another option, another opportunity. It provides more chances for parties in Hong Kong based on your bargaining power, based on your negotiating position, based on what industry you're in, to provide different options. And the flexibility of the CISG allows you to make those choices and still preserve the best of both worlds in relation to your transaction. So it just leaves me to thank both MAA and Witters for inviting this esteemed panel to participate in this discussion and for inviting me to have the honor for moderating. And I thank again also our panel, Sherlyn, William, Gary, and Katie for participating in today's session. I think now we're going to open the floor to any questions that we have either in the room itself or if you are participating virtually using the Q&A function on your Zoom. I see a question over there.
Thank you. And I'm Frank, and I have quite a few of questions. And so first of it is that, may I ask how often have you seen the CISG form is actually used in commodity tradings, like oil, crude oil, like iron? So how often is that?
I have never had a crude oil CISG dispute, but I'm going to throw. Gary, have you seen anything?
I didn't hear the question very well.
Do you have you seen any commodities disputes in the CISG, perhaps specifically in relation to crude oil?
No, I haven't. I'm not saying that I have checked for that, so I'm not saying there aren't any, but I haven't seen any. But if I may say something about commodities, this is actually, I mean, not that I'm an expert on commodities, but this is actually a field where I know that many of the contracts are typically governed by English law, very often English law or New York law. And it is difficult to change habits, or it's difficult also to change this kinds of things, of choices when this it's almost a customary choice. So it's difficult to change the whole industry suddenly. There's also some English lawyers and academics, Michael Bridge, for example, who's saying that the CISG is not proper for commodities. I've never been convinced by that argument, but this is an argument that people in the commodities trades have made quite often. But I'm not an expert on commodities. I haven't handled many commodities cases.
I will note, I mean, some of the key disputes that you'll see on these case digests do involve commodities, like, for example, iron ore, iron molybdenum, I can't say that word, molybdenum, various other matters where the deals are dealing with commodities. But there are, as Gary has mentioned, and as Michael Bridge has also mentioned, there are specific factors in the CISG that affect commodities trades. For example, in terms of the use of standard contracts, the timing aspect is very critical, where even very small variations from the contract could constitute a fundamental breach, as opposed to various other contracts where Article 25 could be a serious issue, or be very difficult to achieve. In commodities, that bar is much lower. So I don't think the point of the panel is to give legal advice, but it is something which, if you are dealing in the commodities trade, is probably something that you probably need to have the counsel or have external advice on in relation to those disputes.
And here's the plug again. All of those sites that we mentioned earlier, for example, that website that has all of the CISG cases, you could actually search on that website for the subject matter. So if you're curious to see how maybe, commodities or in particular specific disputes, take a look at it.
Yeah, okay, thank you. And so the second question is that, okay, probably I'm wrong, and because I haven't followed the logic very clearly, as I know quite just a little or nothing about the CISG, but if my understanding is right, it sounds like a party is not easily or even not possible to walk away from a CISG formed contract even if the opponent party is in fundamentally breach. So means that the contract itself even cannot be avoided anyway. So what kind of benefits there is?
Sorry, is the question that it's impossible to void a contract?
Yeah, avoid the contract?
It's not impossible. So the CISG does actually provide for how to void a contract. It just, it's a different level. And Gary can come in because he's just definitely more of the expert from the practical perspective of when I recommend to clients, when you're drafting contracts or when you're negotiating, for example, the contract that I was just mentioning where we did throw in the CISG to try to extend the contract to the end, we actually added an additional provision of how the parties could also terminate the contract should the avoidance prong not be met. But for contracts that don't specifically provide for separate provisions, then you need to meet the requirements under the CISG. One of the requirements to void a contract is that a fundamental breach occurred and that fundamental breach was not cured or it was not fixed, right? And then under Article 25 of the CISG, it sets out the standard of what constitutes a fundamental breach. This goes back to my moot days, which was over 10 years ago, so I may not get this completely accurate. But for us, we always argued it was a three-prong test. It was always kind of easy to meet the first prong. The second prong wasn't too difficult to meet, but it was always that third prong that was almost impossible to show a court or a tribunal was met. And if you don't meet all three prongs, you don't meet the definition of a fundamental breach, then you can't void the contract based on the fundamental breach. But it doesn't mean that that doesn't exist. I know that there are a number of cases where parties have successfully voided their contracts under the CISG. Gary, do you have anything to add?
Yeah, well, everything you said is right with respect to fundamental breach. But the idea is that the goods have been delivered. Sometimes whether the defect in the goods is sufficiently serious to, say, ship the goods back to where they come from. In an international context, you have to prove that. You have to prove it's fundamental breach, that this. But I should say that with respect to delivery, if the goods don't come on time, you have a mechanism which comes from the civil law of giving a notice to basically the seller receives a notice, and at the end of that notice, if there's still no delivery, you can actually avoid the contract at that time, even in the absence of a fundamental breach. So there are ways in which you can avoid the contract. They're just not as familiar as you would be with the common law, but it is actually a very well-functioning system. It's just a little bit different.
I see we have one question on the Q&A. From the virtual participants.
Diana was going to WhatsApp me. Diana, you're slow. I can't find Diana.
All right. While we try and get that loaded up, are there any other questions from the floor in the room?
You want me to read the question to you, Eric?
Yeah, that would be an option.
The question is, what is case named regarding professional claim against law firms in Europe has discussed? This refers to the professional liability that you've mentioned, Charlene.
Somebody, please email me. You can find my email address on the Weathers website only because I don't have the specific names on me right now, but I know that it's happened.
And any final questions from the floor or virtually? Seeing none? Then it just leaves me again thank the panel and thank William, Gary, Katie, and Sherlyn for your valuable time and your contributions. And for the rest of you, have a good evening.
Thanks, everyone. That is the end of the GIA. Thank you all for coming.
Bye-bye.
Bye, guys. I don't know what you guys see. Bye. We'll be in touch, William and Gary.
Thank you.